Good morning. This is the Board of Standards and Appeals, a public hearing and an opportunity to comment on proposed rules. Up for discussion today is an amendment to the board's amendment of Rule 1-3.5, titled Conduct of Commissioners. We will start taking public speakers. If you can sign in front of Ms. Matias and then come to the dais, you'll have 3 minutes to provide your comments on this rule. And we can begin whenever someone's ready to speak.
Is there anybody who wants to speak on this?
Here.
You have
Please
to
sign in. And then you'll have 3 minutes.
If
You need to sign in first.
He did
Oh,
already.
you did already? Okay.
And just state your name for the record.
Alan Sugarman,
Thank
if
you.
I do speak quickly, I can do this in 3 minutes. If you give me a couple of extra
Start
minutes,
now,
I
yeah.
will be a little, read a little more slowly.
Well, let's see how far you get. Just start. Go ahead and start.
Good morning, I'm Alan Sugarman. I'm an attorney. Just a little of my background, I have a degree in electrical engineering, like some of the people in the commission. I've also had my my work in public service as the general counsel of Roosevelt Island Development Corporation for 2 years during a very trying period. I've been before this board on 2 different proceedings and 2 different Article 78 proceedings of the Supreme Court, 1 appeal and 1 more to come. I'm offering my following testimony in opposition to the proposed rule. I'm not sure exactly what it adds. For me, it adds really not a lot. It reinforces as normal the exclusion of pre-application and other material from the record. Looking at paragraph A, there's no definition of record. In my Article 78 litigations against BSA, the BSA and Corporation Counsel state that only documents electronically filed after the application is filed, that's after, are part of the public record, which is what is filed with the court on an Article 78 appeal. Presents a real problem here because this rule only applies to pending applications. While a lot of meaningful matters occur during pre-application meetings and communications. In many instances, matters may be predetermined. So I've attached here a letter that I got independently through a FOIL earlier this year, showing a letter in 2017 documenting that pre-application meetings started in 2016 involving the chair, and the application itself wasn't formally filed until a year later. None of that would be part of the record or covered by this regulation. I urge you to take care of doing something about pre-application meetings, making them public, and allowing opponents to appear or to at least attend.
I actually have a question
Yes.
about that. So you obtained, and this doesn't count for your 3 minutes, just
Yes.
so you know. I'll stop the clock. You obtained the 2017 letter from a FOIL request.
Yes.
Right. So what aspect of the pre-application materials are you saying are not currently public? If you're able to obtain these materials through a FOIL request, how are they not
Well,
public?
what I would have to have done, and I, by the way, supported the applicant in this, I didn't know about it until early this year, so this was more historic. But the pre-application communications, including this letter, would not be part of the record on appeal.
Right. But why is that a problem, I guess, is my question.
Because the chair had extensive discussions to discuss moving around various things, fire controls, moving doors around. A lot occurred. That should all be part of the record. I don't see what difference it makes whether it's before or after the application is filed. And in my last proceeding here, one of the key issues is whether the applicant could file into the special order calendar. Well, they did, but it seemed to me that somehow they got an indication from someone that they could file that way.
So there's actually a rule in our rules that allows
I
someone...
understand the rules, but I do wonder why they felt that they were going to be allowed to do this. And then an entire hearing, multiple hearings occurred. And what was the board going to do? Say, oh no, we made a mistake, it shouldn't be under the special order calendar?
We
But
do
it has
actually
the authority
do
to
that.
say that, yeah.
Yeah.
I know, but you went through three hearings, And I don't know what kind of communications there were before the application was filed. That's all I'm saying. This rule doesn't help.
Right, so this rule's for something else, though.
Right.
This rule is,
We'll let
it's
him-
in the rule. It says what it applies to. It only applies to after the application is filed. That's what it says.
Yes, it's
With
true.
regard to it's with regard to our conduct, the conduct of commissioners, after such time that an
Yeah.
application is filed. So while I understand what your concern is, something very different than what this rule is proposing to address.
This rule would indirectly sanction not including everything prior to the application as part of the record. The only way I could get it into the record in the prior proceeding was to file numerous foils and beg and everything else, and then file as an exhibits in the main post-application proceeding all sorts of documents that had gone to BSA and BSA was involved in pre-application.
So are you suggesting, first of all, so pre-application meetings are held very often where the applications are never filed, and the board doesn't have an open case, right? And so we have a meeting, and the purpose of the meeting is to help the applicant understand whether or not they have a case that should be even brought, or to discourage them from filing. We can never prevent them from filing, but to discourage them from filing because they misunderstand the application of the statute and so on, right?
That's
What you're
very-
suggesting, and a lot of the time, these pre-application meetings are with institutions that need to keep these things confidential. So, for example, because they're feeling the waters. So what you're suggesting is there can be no situation where a public institution or a private developer who is just testing waters comes and gets information basically from staff, because I do have to say, and this is how I distinguish what goes on at the pre-application meeting. At the City Planning Commission, as an example, it's a very clear title system. The chair of the Department of City Planning is the chair of the agency and manages the agency's staff. And the chair meets with applicants all the time as part of the consideration in advance prior to certification. Once the application comes before the agency in a commission state, the chair shifts into being the commissioner and head of the commission, the body that sits here. At that point, from our perspective, because I don't speak for how the other agencies work, from our perspective, at that point, all communications from outsiders has to be cut, because the application is now pending, it's been filed, and commissioners don't see the materials except in their private review of the materials, their discussion about the materials with staff, and in their discussion about the materials in the public forum. So what you're suggesting is essentially impacting the day-to-day operations of the agency with the chair as the head of the agency as opposed to the commission. And that actually will hamper its operations and potentially mislead applicants.
I have not, to be clear, I did not state you should not have pre-application meetings. At the very minimum, they should be documented. There should be memos to file as to what was discussed. In the situation where you have a confidentiality concern, which I had not thought of before, you can, once the application is filed, then any confidentiality should be removed. So any memos to file would then become public and part of the record on appeal. In addition, where in the cases I was involved in, it was clear to the BSA that I and other attorneys representing local residents and community groups were very interested in the prospective application. And I don't know what kind of meetings were held prior to the application, but we were not advised of any of those meetings. It's clear we were an interested party represented by counsel and presumably responsible. When the application was filed, despite numerous letters, lengthy letters to you, we were not advised the application was filed. It was 2 to 3 weeks later, after the application was filed, that we learned about it. The BSA has no way or no desire or intent to provide notification to people who are on record as to pending potential applications. And even worse, after that, the BSA generally files a notice of comment. We did not see the notice of comment for weeks after it came out. It's a very important document because
But they're
How would-
available,
But wait,
they're
but-
available.
how, if I come
I
down
have a
here
question,
and know it's
Mr.
been sent by the BSA, I would know about it. There's no reason at all you can't have people sign up to be notified about correspondence in a case and just send it out to them by email. We don't need paper copies. You all have it electronically.
Question, Mr. Sugarman, in that instance, where you didn't receive the notice of comments for a couple of weeks and didn't receive notice of the filing, do you believe that you or your clients in that instance were prejudiced by that
Yes,
delay?
yes.
How? How so?
Well, first of all, ordinarily, if I saw an application, I would immediately communicate to you of what I think should be in the notice of comments. But you've already sent out the notice of you may disagree.
So, sorry, so
Yeah.
now I have to, so the notice of comments comes through staff, right? So just to clarify how this process works, right? The application is filed and it's assigned to a staff member. The staff member is the project manager planner, right? Working in tandem with council, with the executive and deputy directors who know about how to prosecute these applications. Commissioners are not involved in that process at all, and the staff's job is merely to get the application ready for hearing. That's all they do. So please don't interrupt. So for example, if they see that the traffic study wasn't submitted, but a traffic study is normally submitted for an application like this, they will say, please submit a traffic study. If they see there was no land use study done, and land use studies are always done for these applications, the project manager will say, please submit a land use study. If they read the statement of facts, and the statement of facts is really unclear, I don't know what you mean by paragraph 3, or you never told us the size of the lot, or so-and-so, please provide that information. That's all that the project managers do, and the staff and the executive staff and council are making sure that the application was properly filed and properly before the agency. For instance, do we have the right kind of Department of Buildings denial so that we are given jurisdiction to hear the case? Is it properly an amendment, or should it be a new case, or et cetera, et cetera? Those are the only things. So it isn't actually relevant to anyone outside of the staff how that application is being managed in its pre-hearing stage. Once it's ready, once the project manager and executive staff decides the application is ready, then it's calendared for a hearing, and still the commissioners don't review the materials. They may know that there's calendar for a hearing and go on a site visit, but until 2 or 3 weeks before the hearing, they don't even crack open the documents, and that's the first time that they're reading about it. And the only exception to that might be a technical question. And a project manager might say, oh, there's some subsurface condition reports here, I don't understand them, and may show them to the commissioner who's the engineer, saying, does this make sense, or should I ask for something else? And other than that, we ask for all the materials once it's in hearing. Once it comes to hearing, commissioners say, oh, we see problems with the application, we need more information. So we would never consider recommendations of notice of comments, because that's from an outsider, because that's effectively hearing the application ex parte, which is not allowed. So that just to make that extremely clear, the fact of you having a copy of the notice of comments will not affect how the staff manages the application. It may give you a jump on your testimony when it eventually comes to hearing, but it won't come to hearing for several months, 2-3 months after those notice of comments at best. So just to revamp your thinking about how the process works.
Actually, I'm well aware of the process.
Well, apparently
Okay,
not.
I take,
Okay.
well, no, I take exception. First of all, many of the opponents are architects, engineers, city planners, people with knowledge of not only those areas of expertise, but the specific project. And I have seen notices of comments which just leave out things that they could ask about. It's not.
You
I'm not
misunderstood what
asking-
I just said.
I know, I did, understood what
Yes.
you said. Thank you.
Okay.
Okay, first of all, there should be, you didn't address the issue, Chair Perlmutter, of getting notice. And I believe that
Getting notice
of the
Notice of the
application being
application as
filed and
opponent- as
getting the
opponent.
notice of comments sent to
But-
opponents by the
Mr.
BSA
Sugarman-
staff or
If-
commission.
If I could just direct your attention to the rule we're talking about today.
I
I
am.
understand that you have lots of concerns about, as an opponent, appearing before the BSA, but I guess I would just like you to focus your comments on your comments on the rule, not particularly all of the policies of
think
the operation of the board.
I would act like some people have before Congress lately. I think if you're telling me it's out of order, then I thought this issue was brought up by the chair. I'm talking about pre-application information. And I'm also talking later on in my comments about issues much more important than this in the transparency of the BSA. I don't know if you read the objections and the hearing statements at the city council hearing a year and a half ago, but this is not what people were complaining about.
What, sorry, I'm not sure what you're
The city
referring to.
council amended the
He's talking about the rule change.
city code on this issue.
On what
A
issue?
year and a half ago, they require anything from the community boards filed with them to be filed with you, and
That's
imposes
right.
a $5,000 fine if
That's right.
people lie before the board.
Yeah, correct.
You're aware of that?
Yes.
That
All of that's been
legislation.
enacted, right. So my question again is, what is your comment with regards to
My
this?
comment
this-
was, I
this
asked the
rule?
chair if she had bothered or was able or fortunate to read the testimony that led to that bill, because this isn't the issue.
Are you opposed to 101?
Yes, I say right here, there's no need for it.
Okay, so, but.
There's no need for
Are
it.
you opposed to, is it your position that you support commissioners communicating with the public or others after the filing of
Application.
an application? You
No,
support-
they shouldn't now anyway. I don't think
So
it's
this is a
needed.
con- this is
Any
a-
commissioner who does that shouldn't be a
Mr.
commissioner.
And I
Sugar-
agree with you. And this
So
is
I don't know
a-
why you need the rule.
It's a codification of this position that we should not be communicating with anyone as soon as an application is filed. And it's very limited in scope to just that so that the public knows that we'd be totally transparent about what we do and how we proceed.
But
Mr.
it's
Sh-
not totally transparent
This
because
particular
it doesn't
section?
include
Okay.
comments or communications. And I have emails from the chair on this Red Rooster thing 2 years before the application was filed
Right.
and a year before.
But if
Those
that's the
should be public.
Miss-
Follow your rule, that anything that ever comes up from today or any day, I wouldn't even know if I'm communicating about something that may one day become before the board. There wouldn't be any possible litmus on that. I couldn't
The
possibly.
litmus is when you speak to an applicant, any of you, you write a memo to file, and eventually that becomes part of the public record if an application is
Excuse me,
filed.
I believe you've had 3 minutes. Thank you
I-
very much.
Wait,
No.
I have
Okay,
another question for Mr. Sugarman. If I can, so you mentioned the city council packet of bills a year and a half ago. I'm not sure if you're familiar with, more recently, the Charter Revision Commission's views on the board and its interests in perhaps changing the composition of the board because of concerns from lots of members of the public that as mayoral appointees, the commissioners are subject to lots of pressures from the mayor with regards to applications. I'm also not sure if you were here last year when we were hearing an application on 200 Amsterdam, and we had council members asking individual members of the board if they had been called and lobbied by members of city council or the mayor. So I would actually refute your suggestion that this isn't what city council has been, isn't one of the things city council has been concerned of with regards to the board members.
Oh, I understand that, but I think it would have been improper with or without this regulation. And by imposing,
Go ahead.
I'm the only
finish.
person speaking here today. Is anyone waiting to speak?
Yeah, there are other people, but
But continue.
Well-
We're still talking. It's okay. Continue. Go ahead.
Anyway, I just by writing a rule this way, it sanctions not including pre-application communications with commissioners
Okay.
in the record.
I have a question
And
about
that's my
I have a question
objection
about
to
that
it.
too. So
My
this,
first objection.
the 2017 letter from Red Rooster that you included in your
Yes.
packet here on their pre-application, they talk about concerns the chair raised in their meeting. Have you reviewed the resolution for that
Yes.
application?
Yes.
And does that resolution reflect concerns about fire safety and egress, some of the same issues that are in the application letter?
That's not the issue. I actually.
I'm asking, I'm just,
Yes,
I'm actually.
I believe it does.
It is, right? Because.
I believe it does,
if-
although fire safety, I wonder why you brought that up, but which is one of the
No,
reasons.
no, no,
I
wait,
raised
let me
this.
just finish my point, finish my point. So, you're talking about the public record, which is the thing that we give to the law department in our defense of Article 78, that defend the decisions of this board, right, the 5 commissioners. Whereas, as the chair was saying, in her capacity as the head of the agency, when she meets in pre-apps, it's 1 commissioner, 2, often 3 members of staff, including project managers sometimes,
including council.
and council. And so I guess my question is, how is that then attended by staff, a record of a decision by a board that's proper for Article 78 proceeding?
In this instance, in the Red Rooster
Yeah.
application, which I supported, didn't know about, but I would support, the chair had meetings with the applicant
Sure.
and the owner and the applicant's attorney.
Okay.
Right.
Pre-application.
Okay.
Now, we don't know how it would have turned out, and we don't know, this could be another case where that was highly contested.
But you can,
It is.
in that case, you could similarly ask for the records from the board of those pre-application meetings.
I could,
Right.
okay, but I don't think I don't think I have to. First of all, it takes time to get these foils.
Yes, it does.
Okay?
It takes time for us also to review and prepare the documents for presentation to FOIL. You understand that as well?
I understand that some of them takes time, but some of it's just a delay in writing to the right people who are collecting emails and things like this. That's how I understood this, the Red Rooster application proceeded.
I'd just like to introduce another reality. You don't attend a lot of our hearings, so you don't hear a lot of the discussions. We occasionally have someone who will get up and say, well, I don't know why in our hearings, while we're hearing an application, an applicant will get up and say, I don't understand why you're asking, why you, the board, are asking us to do this thing now, when at the pre-application meeting, you said it would be okay for us to do X. Well, the first thing is, rarely do we ever say it's okay to do X. Instead, in those pre-application meetings, the requests are, you're going to have a problem with fire code if you proceed like this. So it's not a, you're okay if you comply with this. It's, you will have a problem with fire code. You will have a problem with height. You need to take that into account. Those are the kinds of statements that are said, and otherwise, it's more like, this requires an environmental study, this will require a traffic study, you need to file this on the SOC calendar. It's procedural things that are discussed in the meetings. That's the first thing. But the main part of it is that in those hearings where the applicant says to us, oh, but you said it was going to be okay in the pre-application meeting, we reprimand them right there in public, and we say, nothing in the pre-application meeting was a binding commitment on anyone's part. There are 5 commissioners here, and at the time of the pre-application meeting, we don't have all the facts. We only have a simple drawing that's brought. We have counsel, we may have an owner, we only know a little bit about the site, and so nothing that's said in the pre-application meeting can be relied on in the final outcome. And we say that at all those hearings when brought up. We reprimand that counsel to never do that again, and So hence, there isn't any point in having the pre-application materials part of the record because frankly, they're irrelevant to the record. It's not until all the commissioners have read the materials, considered the materials, and each one with its independent voice speaks that you actually get the outcome of the case.
So it's okay for me,
Nor do the other 4 commissioners even likely know that
No.
there is
Yes.
no pre-application meeting.
Right.
We have no information of that. So to then say that we would be, it would
Prejudiced
setting
or
the other commissioners up to not be permitted to speak about something
They
they
didn't
have
know
no
about.
idea has happened.
Yeah.
I would be very surprised if other administrative agencies in the state would allow a hearing examiner to have had, prior to the filing of the challenge or whatever, to have had communications with the applicant. I do not think I would be allowed to call up a federal court clerk and say, I'm about to file this motion. What does a judge think
But
about
Mr. Sugarman,
discovery motions and
this
things
isn't
like
a
this?
court,
This is
right?
not a court.
I know it's not a court, but yet it's not a court. And if that was true, why is this needed? Look, I know you want to be, you're not a quasi-judicial, I know this is
Excuse me.
uncomfortable.
No.
It's not uncomfortable.
Why is it needed? Is it written down anywhere else? Is this written down anywhere else? This longstanding policy where the commissioners do not speak to applicants after it's been filed?
I think it's
Is that
implicit.
Implicit
Is it-
how?
You think it's implicit.
Okay,
We
so
do
are you
not-
telling me that the commissioners sitting here have had discussions with applicants?
No, I just want to be clear that it's, yes, it's implicit. We all take on this responsibility fully knowing that we have a wall around us all throughout the hearing process. We don't talk to anybody, even amongst ourselves. However, it is always, it seems unfortunately not very clear to the public, and we have had to face the brunt of it at a public hearing to respond to questions, and therefore this rule is to make it eminently clear to everybody. It is clear to all of us here and everybody
Okay.
at the BSA, but it is to make it eminently clear to everybody outside the BSA that this is how we have been practicing and we shall be practicing.
But I oppose it because implicitly, it's authorizing pre-application communications. It's also, it seems to be allowing these site visits where often an applicant and the applicant's attorney might be there or might not. I don't know. The board doesn't keep a record of it. The board members don't make memos to the file that they made a visit on a certain day. If they do make a memo to the file, guess what? It's not in the record.
It's
Yes.
in the resolution.
So it's in the resolution.
That's not in the record. That's the resolution. It doesn't say so-and-so.
Just in response to that, so again, you don't, I don't often see you at hearings, but very often at hearings, when the commissioners make their visits, they say, I visited the site on Friday, I saw cars in the back. I visited the site on Tuesday, I saw this. Oftentimes, commissioners go on their own to do site visits. There is the rare occasion where we do schedule them, and very contested appeals will often talk at hearing about bringing DOB, bringing the applicant's attorney, bringing the board's counsel.
Opposition attorney.
Opposition counsel to those site visits. So I would suggest that it's,
Would you say that you bring opposition counsel?
Yes.
yes, I'm thinking about 18th Street, for instance.
And was opposition counsel in the Sheriff Israel case invited to those site visits?
I don't believe we had a scheduled
Yeah.
site visit for that
You had site
application.
visits.
No, we never had
Those
group
were
site
individual.
visits.
Those were individual. We
But
went on.
where's the memo to the file? I don't understand. When I was a lawyer in law firms, we would write memos to the file about stuff like that. When I was general counsel at Rosewood Island, we would write memos to file.
So let me interrupt
Okay.
just a second. The amount of times we've done any kind of collective visit, I think in the last 4 years has been twice.
Yeah. Right.
And those are very carefully organized visits where both sides, in fact, all sides. I
sides.
mean, we had community board members.
City
on the-
council members.
Yes, so
residents.
attending all. So notes to file, there's a lot of notes to file on those.
Well,
And otherwise, each commissioner goes on their own visits. That's just the way it's done. Everybody has their own car and drives to the sites on their own. So, and that's a requirement, and it's stated in the resolution, and it's basically a requirement, the duties of the commissioners is to go and check out the site so that we know about what we speak. And now we have a compliance officer, in addition to that, who goes and takes photographs of the sites, the more difficult sites, and that is added into the record. And I just want to also add, we're an organization with a staff of 22?
Yeah, 23.
23? And so where we handle an enormous amount of administrative materials, all of the sort of recommendations to improve our operations is incredibly costly to us. And we are trying our best to keep up with all of these concerns, and we'll certainly take your
Yes.
concern
Oh,
about the
can I-
pre-application
may I-
meeting under
may I
consideration.
Just let her
Please
finish.
let me
Let her
finish.
finish.
We'll take your concern about the pre-application meeting under consideration.
Absolutely.
However, the sort of more urgent issue is making clear to the public during this time of the Charter Revision Commission, where it has been stated to us that there was, let's say, suspicion that the commissioners are lobbied by outsiders, say. We need to make this very clear to the public that that is not the case, hasn't been the case, and will not be the case in the future.
Okay, thank you. Much of this I'm aware of. And I also point at the end of my statement where I state that I very much appreciate the help of some on your staff within the confines of what they're able to do and being helpful to me. I am really impressed with their dedication. And one of the reasons I was here is, like you, I was a public official. So if I can just run through quickly in 2 minutes
Go
the rest
ahead,
of my things.
please.
And I don't have an answer to this. Doesn't address communications with the DOB from which the BSA hears appeals. I don't know whether you claim that's an exemption or not, but it doesn't address it.
What do you mean? What specifically what do you mean? Are these from DOB once the application's been filed?
Or before. I'm not distinguishing anymore before or
Okay.
after the
Okay.
application.
Okay.
Okay, I believe, that there should be no distinction, and at the very least, okay, I won't go over that again. DOB, is that considered communication that's not subject to FOIL? Is that your position? I don't know. Okay, so any communications you have with DOB prior to or after the application is filed should be included in this prohibition.
Go ahead.
It doesn't address communications from the mayor's office. Again, I don't know your position under FOIL, whether those are or are not permitted, but I just point out it doesn't address
But so
that.
this is, again, communications with those agencies, with the commissioners, not with staff, right? That's what we're talking about, right? Commissioners, not
Commissioners
staff.
before or after the application is
Okay.
formally filed.
I actually have a question
Okay.
about what you're talking about. Where does it indicate in the rule that this is about FOIL?
It doesn't, but if there are communications,
We're here to discuss the rule today, though. I mean, we are certainly open to hearing
okay, well then,
critiques
it doesn't, does this rule
the
cover communications with DOB? That's all I said. That's what my
The
statement
board is not
says.
permitted to have communications with DOB on a pending application outside of the public record. Yes, yes.
And
What
so
about
if-
pre-application?
But we're not
excuse
talking
me,
about
Well,
pre-application.
I'm talking about
Once the
pre-application.
application
Once
is
the application
filed.
is filed, that's what the language says.
But see, the problem is, once this road goes through, it
I think you've
implicitly
already
sanctions
covered,
pre-application.
you've covered that point.
Yeah.
Why don't you move on
Just,
to
yeah,
other
continue.
points?
I will try. One of the things is when the general counsel is asked to allow this, I think the rule should make clear that the general counsel be asked in writing, the general counsel writes a memo authorizing it, and that thereafter, there be a memo to file by the commissioners that they had such a communication. That's in your proposal, correct? That the general counsel approves,
Yeah,
can
that's-
improve
yes,
this.
yes,
So what kind of documentation are you going to have for that?
We will take that into consideration.
Thank you. What, in the rule or just in the future?
This is not the final version of the
Yeah,
rule,
this is
so
a-
we will
Good.
take that comment into
Good,
consideration.
by the way, I do point out that there's a big difference between what the board says about things and what the Corporation Council says when you get before in Article 78. Because they say, well, we're not required to do this, we're not required to do that.
We don't control the Corporation Council.
Okay, one of the things in here, it doesn't provide for disclosures this is paragraph B, for the reason of a recusal. And in this prior case, Commissioner Hinkson recused herself, and when we asked for a reason, we were told we don't have to give a reason. We're not required. I suggest you be required to give the reason for
Why?
recusal.
Why? Recusal is, once you're out of the room, you're out of the room. What's the difference? What?
Transparency.
No,
Do you want
but
to be transparent or
No.
not?
What's the
Yeah.
difference about, what purpose
When did-
does it, let me finish my sentence. What purpose does it serve for anyone to know the reason for a commissioner's recusal if the commissioner in no way is involved in the case? Doesn't read the materials, doesn't attend the hearings, doesn't get involved in the writing of the resolution, whatever, in the votes, nothing.
Look,
Tell me what I don't know what the purpose.
Transparency.
Transparency
Of what?
for what purpose?
When did Commissioner Hinkson first have a communication with their future employer, who was the lobbyist for the applicant?
But if
When
she
did that first occur?
recused, but
I know.
why is that
But
relevant
what
to
happened
that
before the
case?
date of recusal?
But then you're going to,
I want
looking at other cases. You're looking at other cases, you're not looking at the case at hand, the one at which she recuses, right? So what relevance is it to the case on which she is recusing?
Transparency.
Transparency to what purpose?
The two conflicts of interest among the commissioners, which, as you
Okay,
explained...
so that's the
is-
title
How
of-
is there a conflict of interest
Right.
when she is
Not
removing
there.
herself from deliberation?
Because
I don't
prior to the
understand
remove,
this.
I would like to know the dates of when she first started to discuss potentially
It's
working...
not relevant.
Oh, it
It's
isn't?
not,
Okay.
because she
Look,
removes
that's-
herself from being a voting member
That's-
of the commission for that case.
That's fine. I'll just communicate this on to the city council, people who are interested in this. If that's your position.
Excuse me, can we focus again on the rule? Because
I'm trying
this
to
doesn't
go- I'm
sit-
going-
No.
Are you
Where-
the chair?
No.
Okay, if the
he's
chair would like
counsel.
to, if the chair would like to limit what I say, I will
Mr.
do it.
Sugarman, Mr. Sugarman.
Where does this talk about recusals in the rule?
It talks about
Anywhere.
B. What is B?
B says will not accept any award, plaque, gift, benefit, or thing of value that would result in or create the appearance of impropriety, et cetera. What does that have to do with recusals? That's talking about
Losing or
accepting
affecting their
gifts.
independence or impartiality.
It's about gifts, though. It's about gifts or awards. That's
No
what it's about.
presents.
Benefit,
The
a future employment at $400,000 a year
But
with the
that's not
lobbyist?
permitted under the conflict of interest.
Well,
You
not-
know, so that's a completely separate thing.
All right.
Okay, you can just continue with your.
Just either decide to let me finish or,
Well, but you're making
Don't tell
statements
me.
we need to
Yeah,
respond to.
that's the thing, you're saying things and expecting us not to respond to them.
Do you find that in federal court, the judges give reasons for their recusals?
frequently they do not. And sometimes, in one case I had, the judge gave an extensive discussion of
But
his
most
reasons for...
often they're not required to. Now, hold on. And if we're talking about transparency, and we're talking about, and especially the tone that you're using, suggesting that it is not transparent, or when they're holding the standard to what they hold themselves in federal court, that they're not required to, and oftentimes, as you just admitted, oftentimes they do not give any reason for recusal.
True.
Because it isn't exactly proper, and it's further going to taint the case. If there's a reason for recusal, and one commissioner says it, then all of the other commissioners know it. That creates a risk of tainting the matter. So I just caution, I understand your position, I do, but the medicine is going to create a new illness.
You are concerned about the appearance of this body to the public.
Correct.
This
Mr.
is
Sugarman?
one of the
Why don't
things-
you try Mr. Sugarman?
Yeah.
You got it?
Oh, that's
Yeah, we're in need of repair
Okay.
here. Everyone note, there's
So,
a
this is
class
one of the reasons.
observing, everyone
Anyway,
note,
the
government
general-
doesn't have money.
To continue, the BSA wants to present itself as a quasi-judicial agency, but it really isn't. And when confronted in court, BSA wishes to be reviewed by court as if it was a quasi-judicial agency, not constrained by oath or other administrative law normalities. And I want to get back to the basis of your preamble, because this came in. I already pointed out it wasn't consistent with city council hearing. You note that you've been around since 1916. I don't know why that had to be in your preamble, but since you put it in your preamble, I point out you're still using the format from 1916 for your resolutions. They are not consistent with modern administrative methodology for decisions, which have separate provisions
That'll
for
be our
findings
next
of fact.
rulemaking. It's not relevant to this rulemaking,
It's
however.
relevant, you put it in as relevant to your preamble, okay?
Format
As
of
far
our-
as transparent, you'll see one of my exhibits, yes, you said it's easy to get documents. I filed a FOIL, it's attached here in January, and my response was I'd get it in June. Thank you.
22 people.
And I actually filed a FOIL with DOT last week, and I'm not going to get a response until
Yes.
February of next year, so.
I know, and the problem you have here, which I hope you are going to tell me it's under study and request for proposals now, is you don't have an online filing system where the public can obtain copies of everything, as many agencies do, many courts do, and I provide you the Washington DC zoning department has a complete filing system for every application, every document filed in the application, and any member of the public within minutes after the filing can get a copy. Now, I know that will take time. I would love to hear you say that you are committed to doing this.
So can I just correct that statement? So the Department of Buildings, which has had an online system, I think, longer than any of the other
I'm
agencies,
aware of that.
they do not have copies of drawings online available. The only thing that's online, in the cases where it's applicable, is the ZD1 form, which is an axonometric drawing and some very, very basic zoning calculations, which they instituted when they instituted their challenge program about 5 years ago, right? Other than that, you cannot get drawings of buildings online. You must go to the Department of Buildings and request them, and some buildings are not available for withdrawal. Like, I don't know that you can pull a copy of a school. There are certain kinds of, or a hospital. There are certain kinds of buildings where you need special approval in order to be allowed to withdraw.
I'm well aware of
At the
that.
Board of Standards and Appeals, all of our documents are available for review if you make an appointment and so on. Where it's a sensitive site, I'm not sure exactly how we handle sensitive sites, but certainly anybody who's interested in getting a copy of our application, which includes the drawings, has every right to do that by making an appointment, paying for copies of the materials, and so on.
And in
So,
Washington DC, all I have to do is go online, as well as
That's
many other
Washington,
zoning
DC.
things.
As you
And I
know-
guess what I'm being told is, this is not on the checklist of things that you wish to have in the state.
to make drawings available to the public, no.
I didn't focus on drawings.
Well, you
Now
said
that-
the entire file, so
Well,
that's the
if I
file.
want to go to drawings, I've had plenty of experience with DOB, where it took me 1 year to get the drawings that Sheriff Israel filed with DOB, which showed that those drawings were inconsistent with the drawings you approved. So I'm aware of that issue, and just because they don't do it, doesn't mean you shouldn't do it.
Okay, so since we're back in transparency, and we'll use the example of the court system again. Let's take matrimonial actions. Now, because there's sensitive information in those, you will not find anything on e-courts. You will find a date, you may not even find the name of the subjects. You certainly won't find anything filed online, because it deals with sensitive information, sensitive personal information.
Just about every other case is, the federal courts have had online filing and retrieval for years. Anything that you would provide, if someone came down here to get, then you should have available online. I'm sorry, you're behind the times, you're operating in a 1960s
But you would
mode.
agree matrimonial is not online, right?
But everything else is.
Okay.
I use it every day. I go in the federal system and the state court system. It's all there. I get an application. I get the response.
Do you find
etc.
tax returns online on those?
Things that have
It's
to
heavily
be-
redacted.
Then you can redact it too, but that's not the issue here.
Okay.
The issue is you have nothing,
Okay, go
and you have
continue.
no intention of doing anything.
And we're
Thank you
here
very
to
much.
just, thank you. That's, okay,
Thank you.
great.
Thanks, Mr. Sugarman.
Are there other speakers?
Are there any other speakers?
Any other speakers?
No, I thought we had until operations, or if there's another person sitting there not here to speak, okay. Anybody from the high school want to comment on our hearing process? Okay.
I wonder, is it possible just to,
You have to come to them.
Yeah,
Come to the
please
mic and state your
state your
name.
name.
And state your name and explain a little bit of who's here.
My name is Jason Holt. I'm a teacher at a program called City Term in Westchester, and we're just here to observe. I'm wondering if you could give us a minute or two description of what happens now to this rule. What's the process by which this rule will go forward? Thank you.
Okay.
You could stay up if you'd like, if you
Yeah,
have
you-
a question.
Or you could,
You'll be videotaped, and then you can show it to all the kids. Yeah.
So going forward, we're going to take all of the testimony that we've received into consideration. As I believe you've seen, we posted the notice of the proposed rule on our website. So we're going to be taking these comments into consideration and finalizing the language and working with the Mayor's Office of Operations and the city's law department in terms of the final language. We'll be posting the final language on our website. This is going to be a decision item on the calendar of our next public hearing for the board to vote on. And the final language, once the board has adopted the rule, will be published in the city record and filed with certain other governmental agencies.
Can I have just a point of question?
you'd have to come
You
back
have
to
to
the mic.
speak at the mic.
I also watch your hearings on YouTube. Would you mind if for this hearing, the people here who have spoke identify themselves? Because on YouTube, you don't know who's speaking, especially if you're in this line. And I would appreciate identification of the speakers here today. Thank you.
I'm confused. The speakers here or the
Yes.
speakers?
For the YouTube, you have a YouTube record. When you go on YouTube, I have no idea who's speaking. I never see the chair. But I don't know I would like the
camera angle.
Oh,
YouTube
because of
record
the
to show
camera
the
angle.
names of the people who are speaking
Okay,
here.
why don't
Thank
we
you.
just start from, Carlo, you can introduce yourself. You're sitting there, so just introduce yourself.
I'm Carlo Costanza, Executive Director.
Sal.
Salvatore Sciabetta, Commissioner.
Dara Otley Brown, Commissioner.
Shampa Chanda, Commissioner, Vice Chair.
Marjorie Perlmutter, Chair.
L'Oreal Monroe, General Counsel.
Kurt Steinhaus, Deputy Counsel.
Chase Vine, Assistant Counsel.
Tony Matias, Deputy Director.
Okay. All right, we can close the hearing.
Can.
I just want to state, the reason for the product not being online or accessible publicly online is because of the infrastructure. Is that?
That's
Yes.
one
That's
big
one.
part of
That's
it,
what,
yeah.
I just wanted to state that on the record.
The infrastructure is enormous. We have been creating our online systems by, up until very recently, Carlo was our in-house IT person who developed our online program in his basement, in his spare time. And only very recently were we able to hire an IT person who has now been responsible for upgrading lots and lots of what we now see online. And the scale of the infrastructure that's needed to mount all of our applications in some publicly available database is enormous and enormously expensive.
So I just want to clarify that it's not because we don't want to be as transparent as possible.
Right.
My point was, I don't think it's blocking our transparency. We're doing what we can, with what we have, and being as open as we possibly can be.
Yeah, and I'd like to just state that over the last few years, we've made a lot of progress, both internally and whatever that's led to externally, to, better make things accessible, but obviously there's goals, and we're seeking to achieve those goals, and we're taking all the steps that are necessary, but unfortunately, sometimes it takes time and budgeting, and we work with what we can.
And I just also do want to add that most of our cases, actually, I don't know what percent we've actually done a study like that. It's a huge percentage of our applications are private houses. So putting a person's house online in the public domain, I personally find a little frightening. And schools, right, so we do an enormous number of schools and religious institutions. As we know, schools and religious institutions are targets of
They're sensitive.
yeah,
sensitive,
sensitive
yeah.
targets, and so the idea of somebody being able to review a school or a religious institution's floor plans, we also look at hospitals, same issues, And so.
And a lot of
the-
single-family homes.
No, that's how I started it. Would you, if it was your home, would you want other people to be able to look at, the layout of your house and where your kids are sleeping and so on? And so that's one, and that's for the same reason that the Department of Buildings does not make interior floor plans available so readily, that you have to go through a process to obtain them. Okay, with that.
With that, having no speakers, closing this hearing, April 11th, 2019. That's it.
Okay.
Thank you. Thank you very much. Thank you, everybody, for coming.
Thanks.